Hello and welcome. Disability Law Show. That's what you've tuned into. John Scholes, Sivan Tumarkin with you. Lots of stuff to share today, including 3 things you can do if you've been denied long-term disability. We had to whittle that list down to 3, but we'll get to them in just a bit for sure. You want to reach out right away, 1-855-821-5900, help@disabilityrights.ca as well. Hey, Sivan, how are you, pal?
I'm very good, John. How's it going?
Good, I'm all right. We've got, as I mentioned, lots of things to do today. We'll talk about the Pocket Employment Lawyer website because it pertains to disability law as well. But first, what is happening with you with the week that was?
Again, John, very, very busy week. Again, COVID is still here, so we're getting a ton of people calling us because, they are having difficulty, mental illness, issues with depression, anxiety, all the sorts. I was reading an article a few weeks back in one of the major newspapers saying that quite a few hospitals around the country have now added beds for mental health patients. And, this is not going away anytime soon. And what's concerning me, John, is that many people who have access to long-term disability, to short-term and long-term disability through their work benefits, they apply, and they apply with the help of their doctors who have provided reports saying these individuals are having difficulty, they're suffering, they cannot work for the foreseeable future, they need treatments, and yet insurance companies willy-nilly are just denying these claims. So, it really bothers me when I see this because, again, if you're suffering from a mental health illness, and that can be PTSD, that can be anxiety, that can be depression, there's a whole slew of things that you can be suffering from. Insurance companies, they must pay you long-term disability if you satisfy the criteria under the long-term disability policies that they have. And I think that what they're counting on, and I say this because I've sort of heard through the grapevine, that some adjusters are saying to individuals, just apply for the wage subsidies. Don't bother us with your long-term disability claim or your short-term disability claim. And that's just not true. It's not true. If you have a short-term or long-term disability policy, you've been denied when your doctors are saying that you are unable to work because of an illness or an injury or a combination of both. And when we're dealing with mental illness, it's an illness. The insurance company should adjudicate your claim in good faith. And I see this now time and time again. I'll tell you this, John. We're now in 2021, but just before the conclusion of 2020, we had several cases in our offices, not just in Ontario, but in BC as well, where we were retained on behalf of individuals who were denied their long-term disability claims by their insurance companies, and they had appealed those denials. And again, they went around in circles. The insurance companies maintained these denials. We got involved, and some of our lawyers wrote the insurance companies, not even telling the insurance companies that they're wrong, but asking for a copy of the insurance company's files. And you know what they got back in return? They didn't get back the files. They got back responses from the insurance company saying, oops, we made a mistake. We want to reinstate these individuals. We want to put them back on claim, pay them retroactively what they're owed. And again, what does that tell you when individuals out there are rejected by their insurance companies time and time again? Then they come to us, we write a letter or two, sometimes we start a legal claim, we go through the process, and we force insurance companies to admit that they're wrong. Sometimes they don't admit it. Sometimes they admit that simply with opening up a checkbook, and writing a settlement for 6 figures, sometimes even more. So if you're in that situation, you are fighting a long-term disability insurer, you've been rejected unjustly. You know someone, maybe a colleague, a friend, a family member, please tell them to contact us. It costs nothing to speak with us. It really costs nothing. We will speak with you. We'll correspond with you by phone, by text, whatever it is. We need to understand your situation, and then we can tell you what your options are. And if the insurance company is right, well, guess what? We'll tell you that they're right. But if they're wrong, we will give you the options, and we will empower you to make the next decision, to take the next step. It's up to you if you want to do it, but at least you'll have that information at your fingertips.
Something we started the other week on this show, Sivan was talking about the pocketemploymentlawyer.ca website. We've done it on our partner show, the Employment Law Show, for some time with Lior, but we kind of thought it was important to start bringing it up on this show because within the Pocket Employment Lawyer website, there is a section on disability, quite a robust section actually. So I want you to comment on that a little bit.
So, if you Google Pocket Employment Lawyer, go to the website that John gave you, we created this. It was my partner's idea to create it, so I'll give him credit. But we created this because people sometimes, many times, don't want to go to a lawyer. They don't want to contact a lawyer. They don't want to call a lawyer, email a lawyer. They want to get the information, so they go to Dr. Google. Okay, we call that Dr. Google. And they'll Google their legal problems. And you'll get a ton of wrong information because Google does not understand the nuances of every case. And so this pocket employment lawyer deals with a whole myriad of situations dealing with employment. If you've been let go from your job, if you're harassed, all that kind of stuff. It gives you the right answers for your specific case. But it also has a section, John, you noted correctly, about disability, long-term disability. And it will tell you fairly quickly, I'm saying like within a matter of seconds of you going on it, and it's anonymous, by the way. I mean, you can just close the link at the end after you get your information, but it will tell you if you have a case or not. And if you want to get more information, sure, there's a button you can click and you can get in touch with us. You don't have to. The idea here is that traditionally lawyers have charged hundreds and thousands of dollars for this information. We've created this online website, this tool that gives Canadians this power. And it's literally at their fingertips. You pay nothing for it, and you get accurate information.
Again, pocketemploymentlawyer.ca. Reach out even before you call Sivan or Lior, for that matter. Have a look at it. And even if you don't need them, have a look at it at your leisure. There's all kinds of information, helpful stuff there as well. Email help@disabilityrights.ca. That is the address we use each week on the show. Feel free to use that and reach out to Sivan or James or Tamar, member of their team, anytime and get some answers. We'll get to our first one for the show today. Sivan's from Fiona. Says, I've been on long-term disability for over a year. After injuring my back, my insurance adjuster recently started asking me questions about my habits and daily routine that led me to believe that I might be under some sort of surveillance. I do engage in light housework and small errands, but always while experiencing some level of pain. Could they use that as evidence to deny my claim?
Fiona, the answer is yes, they could. And in fact, I can tell you that they will often conduct surveillance. And when I say often, I don't mean that they have it 24/7, 365. It costs a lot of money to have surveillance. But typically when they start asking these questions, because they're trying to match it up with either surveillance or potentially with any of the clinical notes and records that they've received from your doctors. And what I tell people, John, is that, look, you got to live your life. You got to be truthful. You can't embellish. You should not embellish. You should certainly not lie, but you need to be truthful. And when you are on LTD, that does not mean that you are incapacitated. It does not mean necessarily you're in bed all day. It simply doesn't. I mean, you can be depressed, for example, not being able to do anything at work. It doesn't mean you can't pick up your kids from school. It doesn't mean that. There's no requirement under the law that you be paralyzed, and that's what it takes to be on LTD. So Fiona, my advice is this: be truthful, speak with your doctor, make sure that you're truthful with your doctor in terms of what you can do, what you can't. Express the fact that you're doing certain things and it's causing you pain, your back pain or whatever other pains. Again, if you are truthful, the reality is that the insurance company will not be able to hang their hat on anything and say you're a liar. I think what insurance companies are trying to do is that they are trying to filter out fraud. They're trying to make sure that people are not abusing the system. The problem is that they often cast a very wide net, and many people with legitimate claims get caught up in that net. And again, that's where we come in to untangle that. So don't be afraid to say the truth, Fiona. Don't be afraid also to confirm in writing what you've told the adjuster. So for example, one of the things I will tell you to do, I will advise you to do, is after you have that conversation, email the adjuster saying, we discussed this today on the phone. Here's what I told you. It's what I've been telling my doctors as well. I am feeling this and that, but this is the kind of stuff that I can do. This is what I cannot do. This is what I can do with pain. And just be upfront about it. And at the end of the day, if you're upfront about it and you still cannot do the essential tasks of your own occupation, if you're within that 2-year mark, or any occupation beyond the 2-year mark of LTD, well then the insurance company will not be able to cut you off. And if they do, you come to me, okay? You contact me and we will help.
Coming up here, a very broad question I know you get all the time at the firm. What to do if you're denied LTD? We will tackle that after a short break, which we'll get into right now. The number to reach out in the meantime, 1-855-821-5900, help@disabilityrights.ca as well. Be right back. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Disability Law Show again. John Scholes, Sivan Tumarkin each week here, feeding you the knowledge you need to know, especially if you know someone yourself or a colleague or a family member who's dealing with a long-term disability insurer. Now, you will get denied sometimes. Happens quite often. 3 things you can do if you're denied. Sivan, we'll get to number 1. Do nothing and accept the denial. How about that? Horrible idea. To me, that's like getting a diagnosis that you're terminally ill and you have options and you choose not to exercise any of the options. Look, it's your choice, but not to do anything is just the worst thing you can do, I think. But I will tell you, John, sometimes when people do that, they do it not because they legitimately know what their options are and just decide not to do anything. It's because of one of 2 reasons. Either ignorance, they simply don't know what their options are. Number 2, that I see more often, is they're paralyzed. They are paralyzed by fear. They're paralyzed by the fact that they think that the insurance company is really omnipotent. There's no point challenging them. And again, that is a mirage. I am telling you this as somebody who used to work for insurance companies. They are not all omnipotent. They have a lot of money, but they haven't made that money by fighting legitimate claims. In fact, they hate paying money to their lawyers to defend these claims, especially when they know that they are wrong. Okay? So again, John, when people do nothing, it's usually either because they don't know what their options are, which we're going to now talk about, what your options are, or they are paralyzed by fear. And I'm hoping that through this show, through our radio shows, through the information we give out, you understand that you have a lot more power than you think. A lot more power. And if you know someone in that situation, please tell them that. Okay? Tell them to reach out. Okay, we're not going to bite. We're not going to force you to do anything you don't want to do. We're going to give you information. Information is power, and it's something the insurance company does not want you to have. Yeah, you made a mention of the radio shows there, Sivan. Disabilityrights.ca, by the way, the website to find a station near you that carries our 1-hour radio show, similar to this without the TV cameras, really. 3 things you can do if you're denied your long-term disability. Number 2 is just 1 notch below number 1 as far as bad things to do. It's the A word, appeal the denial.
Yeah, almost every time, in fact, every time that I have seen someone denied or cut off long-term disability, the letter or the email has at the end of it a paragraph or 2 that talk about the fact that you have the right to appeal the decision. And usually they give about 30 days or so to do so. Look, these appeals are useless. They are internal processes that the insurance company has created, has put up, really to create a merry-go-round for you, all right? I sort of refer to the old movie, movie The Matrix, right? They want to keep you in the Matrix. They want you to think that you got to go through this process if you want to challenge them. But, I tell people, my 8-year-old son, if he says to me, I want candy, and I say no, and half an hour later he comes back and says, I want candy, what am I going to say? I'm going to say yes? No, I'm going to say no again, which is exactly what happens with insurance companies. Now, I'm never going to say that these appeals don't work, because you do have, situations where they do, just like you have situations where people win the lottery. I use that example often. But it's rare in my experience, and I've asked the insurance industry in different contexts and on the show repeatedly, show us statistics of how many of these appeals of long-term disability denials, how many of them are actually successful. And guess what? You can't find these statistics. I don't know if they exist. Certainly they haven't produced them. Do not appeal these denials. Contact a disability lawyer. This is what we do. Contact us. Contact someone else. I don't care who you contact, but contact someone who deals in this area of law so they can look at your situation, so that they can look at your policy, so they can look at your collective agreement if you're a unionized employee, and they can tell you what your options are. But don't automatically just appeal those decisions. And here's the other thing. Even if you wanted to appeal, I have never seen someone who has appealed after the 30-day window, on the 31st window, and the insurance company said, oh, you missed it by a day. It doesn't happen. But again, these appeals are useless. I see people who go through them, they get denied again and again and again, and then a year passes, and 2 years pass, and sometimes more. And sometimes, John, people have gone through these appeals over and over and over, only to come to me and for me to say, you know what, there is a statute of limitations of 2 years of starting a legal claim. And guess what? We can't help you because your last appeal, well, the first time you were denied was 3 years ago. So again, you got to be careful of these appeals. Do not appeal these denials. Call me, email me. Let's have that conversation so we can help you.
We're naming 3 things you can do if you've been denied your LTD. Now, number 3, finally, is a good one. This one you want to do, and that is start a legal claim to get the compensation you're owed.
Yeah, and again, I'm a lawyer. Our lawyers, our team, we practice in Ontario, throughout Ontario, British Columbia, and Alberta. And invariably, John, you're going to have people who are going to say, well, you guys are lawyers. This is what you do. Of course you want people to come to you and for you to start this legal claim. Listen, don't come to me if you don't want to. Go to another disability lawyer. Go to someone who knows what they're doing. But the reality is this, and I'm now speaking not just as someone who goes after insurance companies, but somebody who used to work for them. Once you start a legal process, you're taking that power away from the insurance company's hands. Why? Because the insurance company understands that you've started a process now that if they don't help resolve, if they don't come to the table to negotiate in good faith, to settle, it's going to end up before a judge. And the last thing the insurance company wants is to go in front of a judge because they know they're going to get hammered if your case is legitimate, if you cannot work, and if you're entitled to those benefits. And what's worse for them, not only are they going to get hammered by a judge, they're going to have to pay their own lawyers to get there. And then they're going to have to probably pay a portion of your own lawyer's fees. So that's why I'm saying that the legal process is very powerful. No one is above the law. Insurance companies understand this. Once you start that legal process, and again, you have to have a legitimate claim. I'm not telling people to abuse the system. In fact, I often reject claimants who come to me when I can tell when somebody is trying to defraud the system or play the system, game the system. I hate that. I hate that. Our reputation is very important to us as a law firm, as lawyers. So I'll tell you, if I tell you you have a case, trust me when I tell you that, take that to the bank. We're going to force the insurance company. They're going to pay you exactly what they owe you.
Is it not another good benefit of starting a legal claim, not only get you guys on board, but once you start that legal claim on the insurance end of things, now it's out of the adjuster's hands, now it goes to their legal department, and you think, well, that's kind of scary, they're lawyers. No, but it's good because they speak the same language you do, so they understand how to resolve things quickly, right?
You know what, John? It's about relationships. We have relationships with some of the, a lot of the defense lawyers who work for these insurance companies. And it's not unusual for us to start a legal claim when the individual has been fighting his insurer or her insurer for months and months, if not years. We get involved, we start the legal process, and the next thing you know, we get a phone call from the opposing lawyer who's working for the insurance company saying, hey, Sivan, so how about we talk about resolution for this case?
Yeah.
Well, guess what? Because they know us, they know our reputation, they know what we do, they know we have not only the expertise to take this all the way, but the resources which we are putting behind these claims. So, John, you're 100% correct. Internally within the insurance company, it's no longer your previous adjuster that's been making your life hell that's dealing with the claim. It's a different adjuster that deals with resolving these kinds of claims, and it's likely a defense lawyer that either works in-house for the insurance company or works for a firm that's been retained by the insurance company. And, we speak the same language. They understand what happens, what's going to happen if they don't come to the table and resolve the case. And that's how we do it. There's no magic to it. There's expertise, but there's no magic to it. It's just that you have to understand where the pressure points are, where the leverage is. That's what we do, and that's what we bring to the fore on your behalf.
All right, we'll take a break, pal. Coming up here, we'll get to what to do if your long-term disability insurer is trying to push you back to work. We'll tackle that after a short break. The number you want to use anytime, 1-855-821-5900, and email to reach out is help@disabilityrights.ca as well. Coming right back. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for hanging with us. Disability Law Show here. John Scholes, Sivan Tumarkin. Another website we love is mydisabilityquestions.com. You'll love it too if you try it. A place for you to ask your legal questions about your case, your denial, whatever it may be under that banner. Sivan and his team will answer the questions. It also has a searchable database, meaning your question can be asked. You can search to see if a similar one has been asked in the past and answered in full. If not, leave it there and the team will get to it. Sivan, for today from mydisabilityquestions.com, we have Ito. Ito says, I've been diagnosed with MS and have hit 2 years on LTD. One day, the insurance company just decided to cut off my benefits. I feel like they're pushing me back to work when I'm not ready. What happens if I make plans to return to work and my illness prevents me from doing so? What should I do?
So this is a very important question. So number one, John, you notice that Ito says that it's a 2-year mark. That's when the cutoff happened. And again, that's usually when you have a transition within the LTD policy from the own occupation test, right? That, before that, you had to show the insurance company that you cannot do your own occupation to get LTD, to the any occupation test. So beyond the 2-year mark, you have to demonstrate that you cannot perform the essential tasks of any occupation for which you're suited for by training, education, experience. It's unusual to be cut off just like that. Usually the insurance company tells you in advance they're going to cut you off. So to me, there could be a case here for extra contractual damages for leaving this person high and dry and without that financial lifeline. But this person has MS, John. This is an objective, neurological disease, and oftentimes it's a degenerative disease. It's a very, very tough disease. But what Ito's asking is what happens upon a return to work, and the return to work doesn't work out. Well, in the vast majority of LTD policies, you have a provision called a recurrence clause. And typically what it says is that if within 6 months, and again, you got to look at your own policy, but within 6 months typically, if you've tried to go back to work and you haven't been successful, you should be able to go back on LTD without waiting the elimination period, that period of time at the beginning when you apply for LTD where you don't get any benefits. Usually it's about 90 days or 180 days. It's anywhere between that usually. And they tell you, you'll qualify so long as you remain disabled during that time. Well, if you've been on LTD and now you try to go back to work and you haven't been successful within that 6-month period, you should be able to go back on LTD without waiting that time period. The payments should just recur just like that. But what happens is that many insurance companies don't do that. They simply say, oh, you haven't tried hard enough, or your doctors have said that you should be able to go back, so what's wrong with you? And they won't put you back on benefits. Again, that's where we come in. That's where we start that process. We immediately hit the insurance company with that legal claim to jolt them, to force them to put the person back on benefits, or if necessary, to come to the table and negotiate an equitable settlement of the entirety of the claim, of course, with our client's consent. But the key is you cannot just let that be. My concern here for Ito, obviously, is that this is a severe illness, and I'm not sure that Ito is ready to go back to work. And one of the things I want to make sure people understand, John, is that you cannot be forced to go back to work by your insurance company, especially if your doctors have not cleared you to go back to work. Follow what your doctors are saying. Provide updated letters and reports to your insurance company. And if the insurance company ignores that and tells you that despite all this information from your doctors, they still want you to try to go back to work, and if you don't do so, they'll cut you off, call me, email me. Let me get involved, let my team get involved and push back against the insurance company, because the last thing you want is to go back to work against medical advice and make your health situation worse.
I want to get to an email here before we wrap for the day. Sivan, it is help@disabilityrights.ca. By the way, this one from Samantha says, I've been struggling with fibromyalgia and fatigue for some years. I had to take a pause from my teaching job and go on long-term disability benefits. After being on LTD for less than a year, the insurance company said there was inadequate documentation to support additional payments and cut me off. I haven't had much luck in getting the union to help me reinstate my claim. What are my options here?
Well, so first of all, I'd like to see, the medical documentation that you've provided to the insurance company. That's number one. I mean, what's interesting to me is that you provided some documentation early on, and they approved you. So what's changed? If your condition hasn't changed or has plateaued, what has changed for the insurance company? I'd like to see that. Number two, oftentimes, John, people who are unionized employees, teachers, nurses, etc., believe that we as lawyers cannot help them, that they have to go to their unions. And unions, unfortunately, despite best intentions, don't have expertise with disability claims. Now, sometimes we cannot help unionized employees, but in many, many instances we can. And to assess whether or not we can help a unionized employee fight their insurance company, not the employer, but the insurance company for long-term disability, we have a look at the collective agreement. And depending on what the collective agreement says, we can tell a person we can help you or we can't help you. What's happened here, by the way, is that the insurance company obviously has tried to intervene. The insurance company is either ignoring them or disagrees with them. Either way, this person is not getting money in. So the financial, lifeline has been cut. So that's very, very concerning. But I can tell you that we've been helping for years many, many teachers in a variety of situations. So I know that we can help teachers. Again, maybe there is a difference in correct collective agreements, but I would love to see this person's collective agreement, the medical information, and I'd be able to tell this person probably within 2 or 3 minutes if they have a case against the insurance company and what to do about it. So again, don't simply take whatever the insurance company is saying here. You have rights, enforce those rights. Don't kill yourself trying to go back to work if you're not ready and if your doctor has not cleared you to go back. That's the biggest thing to take from here. Follow your doctor's recommendations. Do not prematurely try to go back to work. And if the insurance company is being unfair to you, you know who to call. I mean, this is what we do. Day in and day out, John, we help people deal with the long-term disability denials, and we resolve these cases. It's not hard. You just have to know what to do, and you have to know where the pressure points are with insurance companies.
When they say inadequate documentation, that sounds like a bit of a stall tactic they could use sometimes.
It is. I mean, listen, if your doctor simply wrote on a napkin, this person can't work, well, yeah, that's inadequate. That's not enough. But if your doctor has said, look, this person has fibromyalgia, they have this, they have that, that's what's impairing them. These are their functional limitations, for example. That's all the information the insurance company really needs. I mean, they can drill down a bit more, and I've seen them do that. That's okay. I'm okay with giving them information, whatever they need to assess the claim, but I'm not okay with them simply ignoring and turning a blind eye when the doctors have given them everything they need and have told them this person cannot work because of X, Y, and Z. Here's the prognosis. Here are the treatments. The person is following those treatments. They're trying to get better. When insurance companies ignore all that, that's where we come in. Because when we come in, they cannot ignore these things. They know that if they do, it's at their peril.
Good show again today, pal. We're going to leave you with a bit of contact information, so listen for it. Here it is. 1-855-821-5900 is the phone number. help@disabilityrights.ca. That's the email address we use, and we referred to it and used it earlier on, mydisabilityquestions.com, with a searchable database. You can throw your questions up there. Sivan and his team, like James and Tamar and the rest of the gang, will answer them and get back to you for sure. Thanks for joining us, and we'll catch you next time on the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca.